Karen Whitmore had walked onto my property more than 30 times in 6 months. She opened the gate herself, brought contractors in to measure the land, cut down trees that were never hers to touch, and once let a delivery truck roll straight across the lawn while she stood there, insisting that the homeowners association had the right to inspect anything within the neighborhood boundaries. She never imagined that every single step she took was being recorded by cameras, tracked by GPS coordinates, and documented in a survey file that would eventually end up in front of a judge. When she mailed me a fine of $300 for what she called a failure to cooperate, I did not argue. I smiled, gathered every piece of evidence I had collected, and sent back a legal invoice for $28,500. That was the moment the entire neighborhood began to change sides. Nathan Cole was not a man who raised his voice. At 42 years old, he had spent nearly 2 decades working as a construction engineer, building highways and drainage systems across 3 states, before finally settling down on almost 20 acres of quiet land in a wealthy suburb outside Denver, Colorado. He bought the property long before the neighborhood ever existed, back when the land around him was nothing but open fields and scattered farmhouses. He built his house slowly, plank by plank, with his own hands and the occasional help of an old friend from his engineering days. He liked the silence. He liked waking up to the sound of wind moving through cottonwood trees instead of car engines and lawnmowers. For years, that silence was all he had, and it suited him perfectly. Then the developers came. Within a decade, subdivisions crept toward his property from every direction, cul-de-sacs curling around his fence line, sidewalks appearing where there had once been dirt roads. A homeowners association formed to manage the new community, complete with bylaws about fence, height, mailbox color, and the acceptable shade of beige for exterior paint. Nathan's land, having existed decades before any of it, was legally exempt from the association's rules. He never signed anything. He never paid dues. He never agreed to a single clause in their governing documents. As far as the law was concerned, his property sat entirely outside their authority, an island of independence in the middle of a sea of manicured lawns. Nathan had chosen the land deliberately, years before any subdivision existed on the horizon. He remembered standing on the empty ridge with the previous owner, an elderly rancher who had farmed the property for most of his life, and being told that the soil there was good, the water table reliable, and the winters harsh but manageable, if a man knew how to prepare. Nathan had spent his career designing systems meant to withstand pressure, storm drains that could handle a century flood, retaining walls built to survive decades of freeze and thaw, and he brought that same discipline to his own home. He graded the driveway himself to prevent erosion. He built a small pond on the northern edge of the property to manage runoff during spring melt. Every decision he made on that land was intentional, methodical, and built to last far longer than any trend in the surrounding development. When the subdivision finally broke ground, Nathan watched from his porch as bulldozers leveled the fields that had once bordered his fence line, replacing open pasture with rows of nearly identical houses in shades of beige and gray. He had no objection to the growth itself. People needed homes, and the land was not his to control beyond his own boundary. What he did object to, quietly and firmly, was the assumption that came with it, the assumption held by many new arrivals, that his 20 acres were simply an extension of the community they had just joined, an unclaimed backdrop rather than a working, privately owned piece of land with its own history and its own legal standing. This arrangement infuriated Karen Whitmore in a way that seemed almost personal. At 49 years old, Karen had served as president of the Homeowners Association for 6 consecutive years, and in that time she had built a reputation for control that extended well beyond what her position technically allowed. She sent citations for grass that grew half an inch too tall. She fined a retired schoolteacher for hanging a wreath in the wrong shade of red. She once demanded a resident repaint a garage door because the color, in her opinion, clashed with the neighborhood's aesthetic harmony. Compliance was not simply a preference for Karen. It was a form of worship, and she expected everyone within reach of her authority to participate in it. Nathan's refusal to join the association was, to her, an open wound that never healed. She could not fine him. She could not cite him. She could not force him into a meeting to explain himself. And so, instead of accepting the boundaries of her own authority, she decided to test them. On a cool afternoon in early autumn, with the leaves just beginning to turn gold along the ridge behind his house, Karen arrived at Nathan's gate with 2 other board members and a clipboard full of forms. She unlatched the gate herself, without asking, and walked her small procession directly onto his land, as though she were touring her own backyard. Nathan stepped out onto his porch, arms crossed, and watched them approach with the calm patience of a man who had dealt with far more dangerous people than an overzealous homeowners association president. He asked them, politely, to leave. Karen straightened her shoulders and informed him that as president of the association, she had every right to inspect properties that bordered the community, citing some vague clause from a document Nathan had never signed and never would. Nathan simply looked at her and said that, regardless of her title, this was still his land. Karen laughed, waved her clipboard as though it were a badge of office, and walked further in anyway, her companions trailing behind her like nervous ducklings unsure whether to follow or flee. That first visit should have been a warning to her. It was not. Over the following weeks, Karen returned again and again, each time with a new justification. She claimed she needed to check a drainage easement that did not exist. She claimed a resident had complained about overgrown branches crossing the property line, though no such complaint had ever been filed. She brought a contractor to measure distances for a fence project that had nothing to do with Nathan's land. Each time, she opened the gate without permission, walked the property without invitation, and left without so much as an apology. She began bringing landscaping crews to trim trees she believed were encroaching on association sightlines, cutting branches that had stood untouched for 30 years. She let trucks roll across sections of lawn that Nathan had spent months restoring after a drought the previous summer. Nathan never confronted her with anger. He never called the police during those early visits, though he certainly could have. Instead, he did something far more methodical. He began installing security cameras along every corner of his property, positioning them to capture clear footage of the main gate, the driveway, and the tree line where most of Karen's contractors liked to work. He added a small fleet of drones capable of aerial recording, launching them the moment he noticed unfamiliar vehicles near his fence. He installed motion-triggered sensors that logged the exact time and duration of any activity near the boundary. Every visit from Karen and her associates was now being captured in high resolution, time-stamped and geotagged with GPS coordinates precise enough to hold up in any courtroom in the country. He did not confront her. He did not sue her. He simply watched and waited and collected, understanding something that Karen never seemed to grasp, which was that patience, when paired with documentation, was far more powerful than confrontation ever could be. Over the following months, a pattern began to emerge in the footage Nathan reviewed each evening. Karen rarely arrived alone. She often brought at least one board member with her, sometimes two, as though the presence of witnesses lent her actions an air of official legitimacy. She carried the same clipboard nearly every time, filled with forms that referenced bylaws Nathan had never agreed to, and easements that existed nowhere in the county records. She measured distances between his fence and imaginary property lines that shifted from one visit to the next, always managing to place the boundary a little further onto his land than the last time. She marked trees with small ribbons of orange tape, claiming they interfered with sightlines the association was supposedly obligated to maintain, though no such obligation had ever been written into any governing document Nathan had reviewed. Nathan began keeping a simple spreadsheet alongside his video archive, logging the date, time, duration, and stated purpose of each visit. By late summer, the list had grown long enough to fill several printed pages, each entry cross-referenced with a corresponding video file and GPS coordinate. He noticed that Karen's justifications grew more elaborate with each visit, as though she sensed on some level that she needed a better story, even if she never suspected that anyone was actually checking. He never mentioned the spreadsheet to anyone outside his own household. He simply kept adding to it, evening after evening, the way a man might tend a garden he knew would eventually bear fruit. As autumn deepened, and the leaves along Nathan's property turned a deep, burnt orange, Karen's visits only grew more frequent and more brazen. She seemed to interpret his silence as weakness, mistaking his calm for surrender. She began sending formal letters printed on the association's letterhead, demanding that Nathan open his gate permanently to allow inspection access, claiming that his refusal constituted a violation of neighborhood harmony, despite the fact that he was not a member of the association and never had been. Nathan responded to each letter the same way, calmly and without emotion, citing the specific property codes and easement laws that protected his land from any such demand. He quoted statutes by number. He referenced surveys that predated the association's very existence. He never once raised his voice on paper, and that composure seemed to enrage Karen more than any argument could have. Frustrated by his refusal to yield, Karen turned to a different strategy. She began speaking to her neighbors about Nathan in ways that painted him as a threat to the community rather than a private landowner defending his rights. Linda Foster, a 55-year-old woman who lived 2 houses down from the association's main office and who had aligned herself with Karen's leadership for years, became her most enthusiastic messenger. Linda began telling anyone who would listen that Nathan was hostile toward the community, that he was hiding something behind his fence, that his refusal to cooperate with the association was a sign of something dangerous rather than simple legal independence. Some neighbors, unfamiliar with the actual history of the land, began to believe her. Whispers spread through book clubs and driveway conversations, small distortions accumulating into something resembling a consensus that Nathan was the problem, not Karen. Linda's stories took on a life of their own as they moved from driveway to driveway. What began as vague comments about Nathan keeping to himself slowly transformed into more pointed claims, that he had been seen photographing neighbors' houses, that he had once threatened a delivery driver, that he was building something suspicious behind the tree line that no one could quite explain. None of it was true, and none of it was ever verified. But in a neighborhood where most residents barely knew Nathan beyond a distant wave from the road, the stories filled a vacuum that his own silence had left open. A few longtime residents, people who remembered the land before the subdivision existed, tried gently to push back against the rumors, reminding neighbors that Nathan had lived there peacefully for years before any of them arrived. Their voices, however, were quieter than Linda's, and quieter voices rarely traveled as far. Karen fed off this growing suspicion. She grew more confident with each passing week, more certain that the community was behind her, more convinced that Nathan would eventually break under the pressure of social isolation. During one visit to his property, standing near the gate with a clipboard in hand, she told him directly that he would have to submit eventually, that everyone in this neighborhood learned to fall in line one way or another. Nathan only smiled, thanked her for the visit, and asked her to leave. He did not bother explaining that he had already spoken to a lawyer. He did not mention the growing folder of camera footage sitting on his home office computer, organized by date and cross, referenced with GPS logs. He simply let her believe she was winning, because in truth, every visit she made only strengthened the case that was quietly building against her. The turning point came on an unusually warm afternoon in the middle of October, when Karen decided to hire a professional landscaping company to deal with what she described as an overgrown section along the disputed property line. She did not commission a survey. She did not consult county records. She simply pointed toward a stretch of trees and brush that she assumed belonged to the association's common area and instructed the crew to clear it entirely. The landscaping company, trusting her authority as association president, arrived early in the morning with chainsaws, a wood chipper, and a small excavator, and began working through what turned out to be nearly half an acre of Nathan's private forest. By the time Nathan returned home from a meeting in Denver that afternoon, the damage was already extensive. Dozens of mature trees had been felled, their trunks reduced to stumps scattered across freshly disturbed earth. A section of native grass that Nathan had spent years cultivating had been scraped bare by the excavator's treads. Where a quiet grove of aspens had once stood, there was now an open wound of raw dirt and sawdust, the scent of freshly cut wood hanging heavy in the cooling autumn air. Nathan did not shout. He did not confront the crew as they packed up their equipment and prepared to leave. He simply stood at the edge of the destruction, phone in hand, reviewing the footage his cameras had already captured throughout the day. His drones had recorded aerial views of the entire operation, clearly showing the boundary markers that separated his land from the association's common area, boundary markers the crew had driven straight past without hesitation. His ground cameras had captured license plates, employee faces, and most importantly, several minutes of footage showing Karen herself standing at the tree line, gesturing towards sections of Nathan's private forest, and directing the crew exactly where to cut. He walked the perimeter of the damage slowly, boots sinking slightly into the churned earth, taking note of each stump, each scar left by the excavator's treads, each patch of exposed soil where roots had once held the hillside together. He remembered planting some of those trees himself, years earlier, watering them through their first dry summers until their roots grew deep enough to survive on their own. Watching them reduced to stacks of raw lumber stacked near the wood chipper felt less like property damage and more like watching years of quiet effort erased in a single afternoon. Still, he did not raise his voice. He did not call the landscaping crew back to confront them. He simply photographed everything, methodically, working his way across the damaged acreage until the light began to fade and the temperature dropped with the setting sun. That evening, Nathan made a single phone call, not to a lawyer, not to the police, but to a land surveyor named David Morales, a meticulous man in his mid-40s who had built a career on precision and who Nathan had worked with years earlier on a commercial project outside Boulder. David listened to Nathan's description of the damage, agreed to come out the following morning, and told him to preserve everything exactly as it stood. Nothing should be cleaned up, nothing should be moved. The evidence needed to remain untouched, because what had happened on that land was no longer a matter of neighborly disagreement. It had crossed into something far more serious. David arrived early the next day with a full survey crew, GPS equipment, and a set of historical property records he had pulled from the county archive the night before. Over the course of 2 full days, his team walked every inch of the disputed boundary, cross-referencing satellite data with physical stakes and legal descriptions dating back to the original deed from decades earlier. David worked with the same discipline Nathan remembered from years earlier, moving methodically from stake to stake, cross-checking each measurement twice before recording it in his field notes. He explained to Nathan, as they walked the damaged section together, that boundary disputes usually came down to a handful of feet: a fence built slightly off-line, a hedge planted a little too generously into a neighbor's yard. What he was finding here was different in scale entirely, a sustained pattern of encroachment that stretched across multiple points along the property line rather than a single isolated mistake. The results were unambiguous. Karen and her landscaping crew had crossed more than 60 feet beyond the actual property line, deep into land that had belonged to Nathan and his predecessors for over half a century. The survey confirmed extensive unauthorized use of the land, destruction of mature vegetation, and significant alteration of the natural grade through unauthorized excavation. Before the appraisal even began, Nathan spent a quiet weekend walking the damaged acreage alone, marking each affected section with small flags so that nothing would be overlooked once the professionals arrived. He wanted the record to be complete, not exaggerated, understanding that credibility mattered more than sympathy if the matter ever reached a courtroom. Nathan hired an independent appraiser to calculate the financial cost of the damage. Every felled tree was assessed individually based on species, age, and replacement value. The scraped grassland was evaluated for the cost of restoration, including soil treatment and reseeding. The disturbed section of natural drainage, something Nathan understood intimately from his years as an engineer, would require significant remediation to prevent erosion during the coming winter. Each figure was documented, itemized, and supported by professional invoices, leaving nothing to speculation or exaggeration. Rebecca Sloan, a sharp and unflappable attorney in her early 40s who had handled property disputes for nearly 15 years, took on Nathan's case shortly after reviewing the survey results and the mounting pile of video evidence. She was not the type of lawyer who rushed into litigation. She preferred to build a case so thoroughly documented that opposing counsel would have no room to maneuver. She spent the following weeks organizing timestamps, cross-referencing drone footage with GPS logs, and compiling a timeline of 15 separate incidents of trespass, each one supported by video, photographic, and survey evidence. She was patient in the way that Nathan was patient, understanding that a case built on emotion crumbled quickly, while a case built on documentation was nearly impossible to dismantle. Karen, unaware of the storm quietly gathering around her, continued behaving as though nothing had changed. She received a formal cease and desist letter from Rebecca's office, demanding that she immediately stop all unauthorized entry onto Nathan's property. She read it, laughed, and reportedly told Linda Foster that lawyers loved sending scary letters that meant nothing in practice. Rather than heeding the warning, Karen returned to Nathan's property less than a week later, this time unlocking the gate herself and escorting yet another contractor onto the land, this one hired to install drainage piping, along what she still insisted was association property. Nathan was not present during this visit, having deliberately stepped back to let the cameras do their work uninterrupted. Every moment was captured in clear detail, from Karen's confident stride through the gate to her direct instructions to the contractor about where to dig. She seemed to interpret Nathan's absence as confirmation that he had finally given up, that her persistence had worn him down the way it had worn down countless residents before him. In reality, Rebecca was in her office at that very moment, finalizing the demand letter that would soon change everything. The letter arrived at Karen's home on a crisp Tuesday morning in early November, delivered by certified mail with a signature required. Inside was a meticulously organized document outlining 15 separate instances of trespass occurring over a 6-month period, each one supported by exact dates, timestamps, GPS coordinates, photographic evidence, and drone footage. The letter itemized every category of damage with corresponding financial figures. The land survey conducted by David Morales came to $2,800. Legal fees accrued through the preparation of the case totaled $6,700. The cost of restoring the felled trees and damaged grove came to $9,600. Landscape restoration for the scraped and compacted soil was assessed at $5,900. Administrative costs related to security system upgrades, additional surveillance equipment, and time spent documenting the trespasses added another $3,500. The total, calculated precisely and supported by invoices attached as exhibits, came to $28,500. Rebecca had insisted on precision above all else while drafting the letter, aware that any inflated or unsupported figure could undermine the credibility of the entire claim once it reached a courtroom. Every dollar amount was backed by a signed invoice or a professional estimate from an independent expert, none of them affiliated with Nathan in any way that could later be challenged as biased. She included copies of the survey report, several still frames from the drone footage showing the boundary markers Karen's crew had ignored, and a printed summary of the GPS logs marking the exact coordinates of each trespass. The letter was thick, precise, and utterly without emotion, which made its contents all the more difficult to dismiss. Karen read the letter standing in her kitchen, and according to Linda Foster, who happened to be visiting that morning, she laughed out loud before tearing the document in half and tossing it onto the counter. She declared that the Homeowners Association would never pay such an absurd amount for what she called routine community maintenance. She insisted that Nathan was bluffing, that no judge in the state would side with a man who refused to even join the very association responsible for maintaining property values in the neighborhood. She seemed genuinely convinced that her position as president gave her some form of legal immunity, an assumption that would soon prove to be her greatest miscalculation. Nathan did not respond to her defiance with anger. He simply instructed Rebecca to proceed with filing the case in civil court, confident that the evidence would speak far louder than any argument he could make in person. The lawsuit named both Karen Whitmore individually and the Homeowners Association collectively, given that the board had authorized and funded several of the contracting jobs that resulted in the property damage. Karen, still certain of her own invincibility, hired an attorney from a firm the association had used for years, a man who had successfully negotiated minor disputes about fence heights and paint colors, but who had never faced a case built on this level of forensic documentation. The trial began on a gray morning in late November, the courtroom filled with a mixture of curious neighbors, board members, and a scattering of reporters from the local paper who had caught wind of the unusually large sum involved. Judge Emily Brooks, a composed woman of 58 years with a reputation for patience and precision, presided over the case with the same methodical calm that had defined her long career on the bench. Karen arrived, confident, dressed sharply, seated beside her attorney with the posture of someone who still believed the entire matter was an overreaction. The Homeowners Association's attorney opened by arguing that Nathan had failed to provide sufficient evidence to prove any deliberate wrongdoing, suggesting that any boundary confusion was an honest mistake made in the course of legitimate community maintenance. He argued that the financial figures presented in the demand letter were inflated, designed to intimidate rather than reflect actual damages. It was a reasonable opening strategy, delivered with confidence, and for a brief moment it seemed to steady Karen's nerves. Then Rebecca began presenting her evidence. She started with the survey data, walking the court through David Morales' detailed boundary analysis, showing precisely how far Karen's crews had ventured beyond the legal property line on each occasion. She followed with the drone footage, displaying aerial views that left no ambiguity about which side of the boundary markers the landscaping crew had worked on. She played ground-level camera footage, showing Karen unlocking the gate herself on multiple occasions. Footage that included her voice clearly instructing contractors on where to dig, where to cut, and where to clear. She presented GPS logs cross-referenced with timestamps, creating an irrefutable timeline that matched every piece of video evidence down to the minute. David Morales took the stand and confirmed, under oath, that his survey showed unmistakable and repeated unauthorized entry onto Nathan's land, extending in some instances more than 60 feet beyond any reasonable interpretation of the property boundary. He explained the historical deed records, the original survey markers that predated the association by decades, and the complete absence of any easement or agreement granting the association access to Nathan's property. His testimony was calm, technical, and utterly devastating to the defense's argument of honest confusion. The landscaping contractor, called as a witness by Rebecca, testified that Karen had personally directed the crew's work, pointing out sections of forest and instructing them to clear specific areas, without ever mentioning any uncertainty about the property line. He stated plainly that he had assumed, based on her confidence and her title, that she had full authority to direct the work. When asked whether he had seen any boundary markers or survey stakes on the day of the job, he admitted that several markers had been visible near the tree line, markers that were simply ignored. The courtroom grew increasingly quiet as the evidence accumulated. Karen's attorney, sensing the weight of what had just been presented, attempted a final argument suggesting that even if trespass had occurred, the financial damages claimed were excessive. Rebecca calmly countered by walking the judge through each invoice, each professional assessment, each line item supported by documentation from independent experts who had no financial stake in the outcome of the case. There was nothing left to dispute. The numbers were not estimates pulled from thin air. They were the calculated, itemized cost of real and extensive damage inflicted over half a year of repeated trespass. Throughout the presentation of evidence, several board members who had accompanied Karen on her earlier visits were called to testify as well. One by one, they described being told by Karen that the land in question belonged to a shared easement, that Nathan had verbally agreed to allow inspections in the past, and that the association's legal counsel had cleared the visits in advance. Under cross-examination, none of these claims held up. There was no easement on record. Nathan had never given verbal or written consent to anything. The association's own attorney, when questioned, admitted that he had never actually reviewed the property boundaries before advising the board on the matter, having simply trusted Karen's description of the situation without independently verifying it. The admission landed heavily in the courtroom, undercutting the very foundation of the defense's argument that the trespasses had been conducted in good faith. Rebecca closed her presentation by returning to the timeline she had built at the very beginning of the case, walking the court once more through all 15 documented incidents in chronological order, each one appearing on the screen alongside its corresponding video clip, GPS marker, and written justification Karen had given at the time. Viewed together, the pattern was impossible to mistake for confusion or honest error. It was a clear and repeated pattern of one woman deciding, again and again, that her title entitled her to treat someone else's land as her own. Judge Brooks called for a brief recess before addressing Karen directly once proceedings resumed. She asked her, plainly, why she believed her position as association. President granted her the authority to enter another person's property without permission, repeatedly, over a period of 6 months. Karen, her earlier confidence now visibly cracking, answered that she was the president of the Homeowners Association, as though the title itself were a form of legal deed. Judge Brooks responded evenly that a title within a private association carried no authority whatsoever over land that association did not own, had no easement over, and whose owner had never agreed to join. She reminded the courtroom that property law did not bend to social hierarchy or community politics, and that ignorance of a boundary line, especially one marked by physical stakes and formal survey documentation, did not excuse repeated trespass. Karen's composure finally broke in the courtroom that afternoon. She began speaking over her own attorney, insisting that everyone in the neighborhood had always deferred to her judgment, that she had only ever tried to maintain order and property values for the good of the entire community. Her voice rose, then cracked, and for the first time since the dispute began, she appeared less like an unstoppable authority and more like a woman who had never once considered that her power had limits. The court's ruling was thorough and unambiguous. Judge Brooks found Karen Whitmore individually liable for trespass, along with the Homeowners Association, which had authorized and funded several of the unauthorized projects on Nathan's land. The ruling detailed 3 distinct causes of action: trespassing, property damage, and unauthorized entry, each supported by the overwhelming evidence Rebecca had presented throughout the trial. Karen sat motionless as the judge read through the findings, her earlier bravado replaced by a silence that seemed to stretch across the entire room. Linda Foster, seated near the back of the courtroom, stared down at her hands as the ruling was read, the weight of her own role in spreading rumors about Nathan settling uncomfortably in her chest. Several other neighbors who had aligned themselves with Karen over the previous months exchanged uneasy glances, the reality of what had actually happened, finally cutting through the narrative Karen had spent so long constructing. The court ordered Karen and the Homeowners Association to pay the full $28,500 in damages outlined in the original demand letter, along with additional compensation covering the litigation costs Nathan had incurred throughout the legal process. Beyond the financial judgment, the court also required a formal written apology to be delivered to Nathan, acknowledging the repeated trespass and the damage caused to his property. News of the ruling spread quickly through the neighborhood in the days that followed. The Homeowners Association convened an emergency meeting less than a week after the verdict, and in a vote that surprised almost no one who had watched the trial unfold, the board removed Karen from her position as president. A new leader was elected in her place, a quieter woman who had lived in the community for over a decade and who made it clear during her first address that the association's authority ended precisely where private property began. The meeting itself, according to several residents who later described it, was tense from the moment it began. Karen attempted to argue that the lawsuit had been a personal attack orchestrated against her specifically, rather than a direct consequence of her own repeated decisions. She reminded the board of her years of service, the countless hours she had spent organizing community events, enforcing standards, and maintaining what she called the character of the neighborhood. For a while, a few longtime allies seemed inclined to give her the benefit of the doubt. Then someone raised the question of the association's own financial exposure, reminding the room that the board itself had been named in the lawsuit and now bore a share of the $28,500 judgment because it had authorized and funded several of the very projects that led to the ruling. The mood in the room shifted quickly after that. Residents who had quietly tolerated Karen's leadership style for years, biting their tongues over fines they considered unreasonable or decisions they found overly controlling, finally spoke up. The vote to remove her from the presidency passed by a wide margin. Nathan did not attend the meeting. He had no interest in watching Karen's public removal, no desire to witness whatever final moment of humiliation the board might offer her. Instead, he spent that week doing what he had always intended to do once the legal matter was settled, quietly restoring the section of his land that had been damaged months earlier. He hired a small crew to replant native trees along the scarred hillside, choosing species that would mature slowly over the coming decades. A long-term investment in land he intended to keep exactly as it had always been, private, quiet, and entirely his own. He repaired the section of fence that had been left open so many times throughout the ordeal, reinforcing the gate with a stronger lock, though he suspected he would rarely need it now. In the weeks that followed, several neighbors who had once believed Linda's stories about Nathan being difficult or dangerous found their way to his gate, this time asking permission before stepping past it. They apologized, some awkwardly, some with genuine remorse, admitting that they had judged him without ever bothering to learn the actual history of his land or the reasons behind his refusal to join the association. Nathan accepted their apologies with the same quiet composure he had shown throughout the entire ordeal, never raising the subject of the lawsuit, never gloating about the outcome, simply thanking them for finally taking the time to understand. Among those who came to apologize was a retired teacher who had once signed a petition. Linda circulated questioning Nathan's presence in the neighborhood. She stood at his gate for a long moment before finding the words, admitting that she had never once tried to speak with him directly before forming an opinion, and that she felt ashamed for allowing gossip to shape her judgment of a man she had never actually met. Nathan listened without interrupting, thanked her for coming, and offered her a cup of coffee, which she accepted. They spoke for nearly an hour about nothing in particular, the weather, the changing leaves, the way the light fell differently across the valley in late autumn than it had in summer. By the time she left, something in the neighborhood had shifted in a small but meaningful way, one conversation at a time, replacing months of assumption and rumor. Even Linda Foster eventually made her way to his gate, though it took her considerably longer than most. She arrived on a cold morning in early December, her breath visible in the air, and admitted plainly that she had spread stories about him without ever bothering to verify a single one, driven more by loyalty to Karen than by any genuine belief that Nathan posed a threat to anyone. Nathan accepted her apology the same way he had accepted the others, without bitterness, though he did tell her gently that words carried consequences long after the person who spoke them moved on to other concerns. Linda nodded, said little else, and left quietly, the exchange settling into something that felt less like forgiveness and more like closure. One afternoon, as the last of the autumn leaves drifted down across his restored hillside, one of his neighbors asked him directly why he had never simply confronted Karen sooner, why he had waited so long to file the lawsuit instead of putting an immediate stop to her visits. Nathan considered the question for a moment before answering that a community built on control could never be trusted to respect quiet boundaries, and that real change only came when people were shown clear, undeniable proof, rather than simply told they were wrong. He said that a good community was never built through domination or fear, but through respect, and that respect had to be demonstrated before it could ever be expected. By early winter, the neighborhood had settled into a version of itself that felt calmer, more measured than it had been in years. The new association leadership focused on genuine maintenance issues rather than personal vendettas, and stories about Karen's downfall slowly faded into a quiet, cautionary tale told among residents whenever anyone suggested overstepping a boundary that was not theirs to cross. Karen herself was rarely seen around the neighborhood after the ruling, her once constant presence at community events and board meetings reduced to almost nothing. On a quiet afternoon in late autumn, with the sky painted in soft shades of amber and the last golden leaves clinging to the branches along his restored tree line, Nathan stood at the edge of his property and looked out over land that had finally returned to the peace he had always wanted for it. The cameras remained in place, a quiet reminder of everything that had happened, though he suspected they would capture little more than deer moving through the underbrush from now on. He thought, briefly, about how a simple $300 fine had spiraled into a lesson the entire neighborhood would remember for years to come, a lesson about the difference between authority and ownership, between control and respect. Property, he had come to understand more clearly than ever, was never protected by fences alone. It was protected by patience, by documentation, by a quiet and unwavering understanding of the law, and by the willingness to wait as long as necessary for the truth to become undeniable. As the wind moved gently through the trees he had planted, carrying the scent of cold earth and distant wood smoke, Nathan allowed himself, for the first time in months, a small and satisfied smile, knowing that the land beneath his feet, and the life he had built upon it, finally belonged entirely and peacefully to him.